AI technology.
Thank you all for coming here. Sorry about the delay. We're still trying to figure out some things, and I think we're starting to. We're just going to start with the panel in the meantime, which is organized by Fraunhofer ISI and the platform Privatheit. Thanks to all of you for joining us, and of course our speakers. We're going to be talking about risk, which is what I've been working on ever since pretty much 2013. And I figured I'd find some interesting people to talk to about this. Now, you all know it started with the GDPR. If you're from the financial sector or any other areas, of course, it started way before that. But for us, data protection people, it started with the GDPR. And how did we end up like this? Well, the DSA and the AI Act came along. And the DSA introduced the systemic risks. The AI Act covers really any kind of risk. We have the risk of self-replicating AI systems, whenever that is going to happen. But we also have, of course, risk of discrimination for individuals, for groups. We also have risk for society as a whole in there. So there's things we can work with. We now have the DPIA and the FRIA. We also have what I like to call the hidden FRIA, the Hidden Fundamental Rights Impact Assessment, which I'm talking about the risk management systems that are kind of like, you know, for those who appreciate them, maybe even nicer than the Fundamental Rights Impact Assessment, both in the DSA but also in the AI Act. And we'll look into all of those things. I'm actually not here to talk, so I'm going to stop here. We'll look into several cases, specific and then more abstract, and finish off on the geopolitical level. And I'll just introduce the speakers for you. Right next to me, we have Isabel Barbera, who is the co-founder of Right. She has a multidisciplinary background in privacy and security, engineering, law, and ethics. She guides organizations in the design and implementation of responsible digital solutions. And she has created a report on LLM privacy risks that the EDPB has recently published. And she's also currently working for the Council of Europe Data Protection Unit that is extending that research to propose an international privacy risk management framework for all LLMs. Then on the other end of the panel, we have Alyosha Ivanovic, who is a lawyer and a journalist who works at EDRI and covers issues related to illegal state surveillance and hacking, online freedom of expression, and the effect of technological tools on migrants and asylum seekers' fundamental rights. For his recent works, you can just look at the EDRI website. There's a lot of stuff that they're doing, obviously, and his stuff is there as well. Then we have Irmak Erdoğan Peter, who's right there in the middle. She has a background in human rights and criminal law, and she has worked as a lawyer focusing on human rights and media law in Istanbul. She went into academia and did her PhD focusing on the use of risk assessment technologies in criminal justice. She currently works in the Starlight Project, which deals with the development and deployment of AI technologies in law enforcement across various member states. She recently published an article titled Diving into the Iceberg that's looking into the lack of transparency in AI of law enforcement. And then we have Katie Nolan. She's an assistant lecturer in law at the School of Social Science, Law and Education at the Technical University of Dublin. Her research focuses on digital governance, data protection law and fundamental rights in EU law. She has an article coming out with Orla Linsky and Maria Helen Murphy called The Digital Empire or Digital Fiefdoms, Institutional Tensions and the EU Right to Data Protection. That's forthcoming in the Cambridge Yearbook of European Legal Studies. So look out for that. And to kick off the panel, I'm just going to turn to Isabel and ask the first of our questions, which is, so how is risk regulated in the EU, and what role does standardization play there, and how does your work relate to that?
Can you hear me well? Yeah, I think so. Yeah, you asked me the most easiest question, especially when you work in the field of risks. It's something I feel, especially because I work in the technical field and in the legal one. And really, the discussions are so different. So I will explain to you now also the difficulties that we have in the standardization about the specific question of what is risk. and also the influences of how it's regulated. And I wanted to, before I get into a bit more technical, I know I only have like 5 minutes, so I have to go we will go later more into the details. But I thought I would start, and this also because for the ones of you that have read my reports from the EDPB, you will see that the privacy risks for LLMs, some of them are really technical. Of course, we talk about data protection and privacy. And what I find really nice of this panel is that we touch more about the harm also for people. So there's not only how to protect the data from the technical perspective, that brings me also to these sort of discussions about what is really risk and they jump into really harms and impact. And I wanted to start in that sense with just a thought about, for the ones of you that have children or maybe nieces or something like that, and family relationship with children where you want to teach them at some point what are risks, right? You want to teach them to protect themselves. And how do you do that? I mean, you have different type of parents, right? Some are really super protected, and they are telling all the time, don't do this, don't do that. Others are more from the opinion of, well, learn by yourself, be completely risk, autonomously as learning by yourself with, of course, the risks that implies, right? But eventually, you want that they learn not only what can go wrong, but also what could be the impact, not only for themselves, but to the others, right? You want to learn. We are in a society, in a complex society, and eventually, if you don't learn the impact to others, then maybe we are not a society, right? So I will go back to that later about, because for me that summarizes one of the biggest problems that we have in the field of risk management and in not only in privacy, in fact, but in the field of AI, that is where I mostly work lastly. Regarding regulation, and I thought I can just summarize this for you to understand how difficult it is to define risks. Okay? Just the short definitions that we have, like in the GDPR and the AI Act, and that I just read from the GDPR, like what we have in recital 76. So the risk would be the likelihood and severity of the risks to the rights and freedoms of the data subject. So we are focusing really the rights and freedoms of the data subject. And something that I like that in this part of the recital is that it comes to say that it should be determined by reference to the nature, scope, context, and purpose of the processing. And I say this because it's really important, of course, and it's the more difficult part, and we're going to talk also about that, and how to determine really what is harmful for who, and how is that linked to the context. Now, if we look to the AI Act, and I don't get into the risk taxonomy of the Act, because then I will need here 2 hours lecture. So if we look at the definition of risk, it's a combination of the probability of an occurrence of harm and the severity of that harm. So there we already see a relationship with the probability, likelihood, probability, a bit more of a technical term in this case, but again, I'm not getting into that technical discussion now, and the occurrence of harm and the severity. Now, when we work in a standardization, so you see in these 2 cases where the relationship with likelihood, probability, severity, the relation to harm, it's there. With different perspectives, but it is there. Now, working on the standards, and I'm working on the standard for AI risk management, the European standard, because of course we have international standards, but I'm working in the ones that will be eventually, the expectation is that will be harmonized and that will be useful to demonstrate conformity with the AI Act eventually. Some of the things that we are facing, especially in the beginning phase, now we of course reach a consensus, otherwise at this phase would be catastrophic to be at that level. But one of the main issues with the definition of risks. I mean, you want organizations that are already being certified, or they are basing their processes in some risk certification, like the most common, the 31,000, or for instance for security, 27,001. You don't want to suddenly create a framework that is going to be completely different, right? So that in fact the intention of the AI risk management standard is to create a horizontal standard that is useful for everybody, and that changes are not so big. But now comes the problem. I mean, risk is defined differently in all these standards. I mean, if we look at the ISO 31000, risk would be the effect of uncertainty on objects. Yeah, I mean where is harm there? Where is likelihood severity? If we look in 27001, the potential that a given threat, now we come into more the technicalities of and the discussions that we have in the standardization. Potential that a given threat will exploit vulnerabilities of an asset or assets and thereby cause harm to an organization. Well, good luck. You can imagine, in fact, this is something, I mean, I cannot explain all what we do in the standardization at this moment because some parts are confidential still and so, but still, for all what I can say, this is something we're still trying to find out consensus because it is difficult. You cannot ask to an organization that is looking at risk from a perspective of threats to an asset to suddenly look at how we look in the AI Act from the product safety perspective is the harm that this product could cause to people, to the ecosystem. So that is something that from the security field, for instance, we need to switch. We need to make a change there in perspective and learn that it's not only what comes as threat, but also, but also what happens from that asset to the external world. And that brings me, and maybe later I have more time to explain that, to all the discussions that we have about the definition of hazards, definition of threats, and what does it mean in risk management. Of course, in safety product standardization, you don't really talk about threats or vulnerabilities, you talk more about hazards. And one of the main discussions, and with this I finalized here, that we have, especially in the beginning, it's in the field of fundamental rights, for instance, we don't really talk about hazards. So we see it like something more, something that already exists, physical danger that is there, and doesn't have to become a risk. And I have had time later, I will explain how that process works to really become a hazard that can become a risk. But that is something that we had to, with all the experts, discuss. How do we do this? I mean, how we are going to link the term to hazard to really what the impact is to fundamental rights and harms. And I let it here, more later. Thank you.
Perfect. Then I turn to Irmak now, who will maybe tell us a little bit about the law enforcement context, and especially like how risk assessment and profiling, of course, which often comes along with that in that context, how they affect the individual in that area.
Mm-hmm. So just a few words about the risk management and generally like risk-based regulations. It's more like, first of all, interlinked with the neoliberalism of the state retreating from the public service. It's also linked to, of course, privatization of the public service again and having decentralized way of managing things. Risk management means not eliminating risks. It's like reducing risks. It's a very different way of thinking than binary rights system. You either violate or not, but risk is about something is about to happen and you centralize all your forces to prevent it in a way. And AI Act is doing it like letting different actors having their own self-regulation, but at the same time retreating and watching what they're doing. But what it means in criminal law particularly is interesting because criminal law per se starts with the harm. Like you starts with an action and the harm happens. And then suddenly it's not a risk-based system and you're introducing the notion of risk into a system which is not fit to it. And what they're trying to do now is like we have limited sources for the typical public law enforcement. Why don't we focus our sources, not waiting till the crime happens, but before, if the police can be at the right place at the right time, then we can protect people more before that happens. But the problem with this way of thinking is where do we see that the person is culpable? Like what is the culpability then? If there is no decision making, if there is no action taking, and then you are taking responsibility for it. It's not about that. It's about some interconnected data which tells, okay, past crimes happened there at this point and at this moment. And then what do we do with this information? Do we send the police to just show their presence that people would back up? it doesn't work for all types of crimes. For gun violences, for automobile theft, yes, it works when the police is present there. But for different kind of crimes, this kind of technologies are useful or not is disputable. And the second problem is, if the police goes there and instead of making a presence starts to arrest people based on just data, and if you feed the system with this information, it means that you make the community encounter more police force, and in return being more and more stigmatized at red zones. The second problem, which is even worse, is like profiling based on the personal characteristics. And it means that you take all the data about the data that you cannot change. It's like static data about family, if they committed a crime before. It's about your past, your family's economic status. And there is also changeable data. It's like your marital status, which is in, I will dive into these technologies more. It's like all this irrelevant data is there, and these things can change, your employment status and all this. But the problem with these technologies is they don't provide counter information. For example, you can be without a job because you had gone through an accident, and that's why you are dependent on social help. But just because you are dependent on social help, you are kind of categorized as a nuisance to society by these technologies. And the problem is they are not based on decision-making trees, so we cannot see which data is very relevant and useful to make this kind of determinations. And the second problem with that is like if you use it in criminal procedures, then actually you are criminalizing people based on static data and changing data, which is not updated in these systems. So my question is, AI Act took already some measures against some forms of these systems, but before taking all these measures, did we think that the ground zero question, why are we using these technologies? Are we using it to increase, what do we expect from law enforcement? Should they work as social officers, going to the problematic neighborhoods, talking to people, trying to set out the problems? Are they trained to do so? Are we going to use it as deterrence, the presence of police? Is it going to work with the community relation? Are we going to do community policing? Are we going to do, again, the old school policing where we put people in the criminal justice system? So the problem is we don't know, first question, like why are we using these technologies? And though AI Act draws some red lines, it says like, okay, you can play with your high-risk area and report everything, but when it comes to prohibited area, okay, you stop there. But the problem is, how far can you go with the high-risk technologies? Because the very little distinction is, if you use these assessment tools, only them, to criminalize someone, it's forbidden. If you use them, plus you find evidence, it's high risk. But if you use them, again, why are you using it for? Is it a character, personality trait that's very relevant? Imagine a judge listening to all the facts like, how was your family life? Were you talking to your professors in a nice way? Did you ever lose your job for a long time? Like all these questions would be super irrelevant, but we are using these technologies still for what is the question? And I'm thinking just because we made the state retreat from visible surveillance doesn't mean that it's not there, and it's even becoming more challengeable when we introduce different actors without forcing them to be transparent, without ensuring that these technologies are used for the right purposes. So these are my first few remarks, but I would like to later give examples of the technologies and court decisions.
Perfect. Thank you, and on perfect time. That's great. We'll go on, and I already love the question of why are we using this technology. I think this is, when it comes to AI, a very good question. But first, we're going to look into a little more of these technologies with Alyosha, and maybe you can tell us about how risk in the securitization that we've been seeing along the border, how that's been going with human rights and for the individuals who are affected.
Yeah, thank you. First, I would like to start by saying that the EU is misusing the concept of risk when it comes to managing or dealing with migration. I'm not going to talk about particular definitions as Isabel did. I will be talking more about the broader framing on how migration is being treated in the EU, and it's very important to say that risk is being used as a weapon for surveillance, for exclusion. As you said, this is something that that has to do with risk management, but in the same time that you are allegedly managing a risk, there's an erosion of rights of the people who is being managed, and it's really telling that issues relating to migration are being dealt with in the same scope as issues relating to criminality, as if migration was a criminal act. So we know that this concept of risk now is being incorporated in more and more EU legislations. We've mentioned the DSA, the GDPR, the AI Act, that I will be building more upon the AI Act after on, but it's also affecting migration regulations. First, it's important to say that what is happening with migration regulation is that the phenomenon itself is being framed as a risk to the EU, so that comes before the actual texts that talk about risks have been adopted. So for years we've been seeing a rhetoric which frames migration as something that can be a threat to national security, can be a threat to our lives, and so on. And this has stayed within policymakers. And in the last migration pact that was adopted last year, we see how that's solidified in law. We have some mentions to risk in those, and a good example is, for example, the screening procedures that now every person that's entering in from an illegal crossing point into the EU will be subject to. So this is a risk assessment, not about which risk this person can face, but about the risk that this person can pose, either to national security, either to health, which is a very cynical way of looking into the most marginalized or most weakened position person that you have in your society. So this has been kind of this weaponization in which framing migrants as risks and treating them as potential threats is going to treat them as potential suspects. But this is not something that has just happened with the last, we could think that this is because the far right is now enraged and so on, but we have had things like the Eurodac, which is this system in borders that takes biometric data from everyone who's entering into the EU. That's been on place for several years now, and as we know, you do that to control, to criminalize the people that you are taking their data from, because it's a way of having them in your radar, so to have them under control. So instead of giving protection to these communities, you are controlling them with the excuse of the risk. And that's more or less the whole framing. We are treating mobility as a threat, migrants as a risk, and we are overlooking when we say, okay, let's treat this risk with technology. Let's make it. Let's put technology in our borders to make it easier to deal with this risk. When countries or Frontex are doing that, they are forgetting about the actual risk that these persons are facing. And we are talking about risks such as violence. We're talking risks such as pushbacks, and we're talking even about potential deaths. So it's like really, really clear and real risks, and not something rhetoric. And this is not being taken into account when developing technologies that are being used in this area. And we could even say that AI, mainly, it's being a driver for this exclusion and to further securitize our borders. Things like predictive analytics, in order to know which are the migration routes that people are taking, to be able to then perform pushbacks, is something that technology is being used for. Also biometric surveillance, as the Eurodac systems, or other types of technologies like prison-like facilities in detention centers, which are, as if you read about the Centaur project in Greece, it's becoming a kind of dystopian places without humans, in which cameras and digital elements are controlling everything, so there's no human interaction almost, which further deepens into the dehumanization of people who are in these detention centers. But they're not only doing that, they're not only controlling with technology, technologies are also taking decisions in this area. We are seeing more and more automated asylum seeking procedure risk assessments done by this type of technologies, and also some really dystopian type of technologies, such technology that was, for example, tested by the EU. It was called border control, and it was kind of an avatar of a border guard that you had to have a conversation with in your phone. You had to register before crossing the border. You would have this conversation with an avatar, and it would record you, and based on the micro movements of your face, of your eyes, of your mouth, it could tell whether you were telling a lie or not. So it was kind of a polygraph system, a lie detection system that was based on AI. This is totally pseudoscientific, has no basis whatsoever. on top of the attacks on human dignity, on basic human dignity that it poses to the people this is being used upon. And all of this has been used with the backing of the EU legislation. And in particular, we were thinking, okay, if we are framing migration legislation with putting migrants as risks, maybe the risk-based approach of the AI Act can help us on that. But that's not been the case, particularly in the migration side, because so we agree that the AI Act is a step forward in order to protect rights, because it's putting at least some red lines. It's a piece of legislation that could be perfected, but it's also something that we as a digital rights advocate can work with. But when it comes to dealing with migration, it has several very meaningful gaps. And well, as you know, the AI, well, I can maybe build on that on further questions on how AI Act is failing to protect risks that are faced by micropopulations. Thank you.
Okay, thank you very much. Then from these very specific cases and applications of these technologies and the twist in risk that we're suddenly seeing in those two areas, I want to turn back to the more grander picture, maybe, for an overview. And just maybe Katie then can tell us a little bit about what this shift to the risk-based language that we're seeing in all these new acts actually means for fundamental rights in the given geopolitical circumstances that we're in this moment.
Sure, thanks so much. And so you might say, well, what does the idea of risk management have to do with broader kind of geopoliticization? Well, one of the connections I really see between these is the way in which rhetorical use of language can hide some of the ideological underpinnings. And I do see a connection here between push for more risk-based approach and then some of the shifts in policy orientation we are seeing in EU digital law in terms of the, let's say some of the Trojan horses that might be hidden within the use of very palatable and friendly language. And so I think Irmak hinted at this already when she said the word neoliberalism. Perhaps we'll come back to that in broader discussion. And I think, again, when I was thinking about this, I found it helpful to think about the idea of mystification. And so many of you might be familiar with this idea of, it comes from critical theory, and the idea that you can have a plausible misrepresentation of an issue. And because it is plausible, it can be used to great effect, and its acceptance or adoption can serve to really cement the benefits of one privileged group or one socioeconomic class. So language and the ability to frame the system, as Alyosha has been saying, can serve as this tool to benefit one group of interests or another. And so again, I think it's useful to think about how are we framing these issues, what terms are being used to justify the various changes that are being proposed at the moment. And again, to remember, we are in times of multiple crises, and that means it's really a prime time for power grabs. The age-old story, in times of crisis, beware those who are offering simple solutions to difficult issues. This can be a prime time for someone to offer solutions in order to cement their institution or their promised answer to those solution or to those crises. And so then to speak first to the idea of risk-based language, I often think of this as putting forward a sort of rational, efficient mode of regulation of problems. And of course, as Isabella said, there's lots of different ways you can think about risk. Like, it's enormously challenging to try and calculate risk. And this, I suppose, again, it can be helpful to think that like risk modeling, is a mode of understanding a problem. But that mode or that method, it carries certain assumptions within it and affordances. So it comes from probability theory. We could have a long, perhaps slightly nerdy discussion about probability theory and the assumptions that underpin it, but maybe that's for another day. But nevertheless, this sort of, what we're doing is creating a metric. If you metrify something, it suggests an objectivity. If you can calculate it, there must be a type of neutral expertise here that we can benefit from. But often, of course, This obscures the kind of qualitative, contextual, rich analysis that is necessary when it comes to looking at, individuals' particular circumstances. And therefore, and lots of risk scholars have thought about this, I was thinking about Eimer's work in particular, but in order to apply a risk assessment, you necessarily have to be reductive, because you have to reduce all of these complicated phenomena into something that is calculable. And in doing so, something is translated, something is lost. So by riskifying, I'm making up a few words here now, riskifying these questions of fundamental rights, you can eliminate a lot of the nuance, complexity, you can dehumanize those who are affected. And so it's kind of a type of like epistemic capture, by who gets to frame this problem, who gets to rationalize. They are imposing their vision of the world on these problems, their vision of appropriate solutions. And of course, that can be at the cost to others. And so then more broadly, and Alyosha and Irmak have both suggested this already, a push towards risk-based regulation is often, code for deregulation. Oh, we need something that is more proportionate, more risk-based, i.e. reduce the rules that are applicable to us. And we are increasingly seeing this in the digital sphere. We've heard so much talk about simplification over the last few days. And again, this push towards risk-based approach often comes in hand with self-regulation or co-regulation. Treat us, the regulated entity, to solve this problem. In other words, leave us alone, let us make our money, you butt out. And so again, these risk assessments are often put in the hands of the regulated, and within that, they can often become calculating, well, the risk to the company. That's what it becomes translated to. What are acceptable risks that we can bear internally, as opposed to orienting towards, those who are affected. So again, I see this as a sort of power struggle, that we have this exertion of a kind of privatized ownership or control over the conditions of our digital and information infrastructure. And so part of that language is coming through language and framing and rhetoric. So if we turn to the broader geopolitical circumstances, which I think is a pretty euphemistic term, I think, again, we have to acknowledge we're in a pretty troubled place right now. The very notion that individual rights frameworks can secure justice at all are really challenged in the face of war, in the face of genocide. And then, the EU digital law is just one little manifestation, I think, of broader challenges. And so again, we know EU dependency on US tech infrastructure has kind of long been knocking around as an issue that people are concerned with, but it's attracted this kind of fever pitch at the moment because of the breakdown in EU-US relations. And in particular, if we think about sort of US tech complicity in the US administration of the moment. And so again, I think if we look to the EU and the type of ideologies that are being surfaced through coded language, we can think about the narrative of competitiveness, that now it's being associated with this sort of deregulatory push. We're still kind of waiting to see what that will be. But nevertheless, it is, a type of coded language. And additionally, the push for more digital sovereignty. And that I think really resonates with what Alyosha was saying, and that reorientation from the rights of migrants to the risk to Europeans is a pretty significant shift in terms of where our attention should lie. So I think we need to acknowledge that these kind of terms, they're very open-ended. They're subject to lots of different interpretations. So that can obviously be very useful politically. You can build coalitions with lots of different people. But it can also obscure a range of motivations, and it can sanitize or whitewash some of the real power struggle we are seeing, and the extent to which we are mystifying or I'm almost finished, or obscuring the effect on the vulnerable. So again, all of these terms in theory, they're great. They connote that we're making progress, we are quantifying, we are being rational. But if we push a little bit deeper, we have to remember that there are ideologies inherent in these terms, that the misrepresentation that is being presented to us is that there are great solutions that we will all benefit from. But of course, if you dig a little deeper and think, well, who's telling us this? There are clearly those who will be victimized and made vulnerable. And so I think we have to be cautious and contest these framings, contest these use of languages, and to try and resist a reduction of fundamental rights into a mere business risk.
Perfect, thank you. I think this has given a really nice overview of what risk can be. And I gotta say, I'm still learning, obviously. And when I looked at risk in the GDPR, for instance, I was kind of enthusiastic because I just figured, okay, now we have fundamental rights in the GDPR. Now we can do all the fundamental rights in the GDPR. And that seemed great, and I think it still is, and it can be. But also we see with your perspectives now the less privileged side of things. And as Katie has been telling us, what this might lead to as a cautionary tale as well. And I think Isabel is also working at it from a similar perspective to me. So I wanted to ask you about, well, two things, and maybe reflecting on what they said. And obviously, I'm talking way too long now, but please try and keep it short so we can still get some questions from the audience. What are the harms or the damages that you're working with, that you're trying to prevent? And also what, after hearing all this maybe, do you think can be the risks to fundamental rights in the standardization processes that we're seeing, or in the certification and all the processes that we're seeing currently?
Okay, it's like I have like the technical answer on how I really feel about that. So I don't know which one you want to hear about. Because the thing is that technically it's, I think we are really doing a good job. At least the efforts are tremendous, but it's complicated. I mean, the field of fundamental rights is it's a field by itself, of course, and not everybody has that knowledge. So embed that into a technical standard is it's complicated. But I think we are, from a technical perspective, again, we are doing a good job. I cannot tell. Well, I think I'm pretty sure that won't solve the problem. I mean, that now comes my personal opinion. It won't solve the problem because, and maybe that links to your question about harms, because many things can go wrong. So that's the reality. And how do you have, that tool that tells you that everything that can go wrong? And I would like to say that standards can be a good tool, like any other tools that are there to at least get a perspective of things. But for me, willingness is one of the first things you need to have. Willingness to really find out how you could harm others, and not only your organization, but what your specific, and it's hard for me to say just product, like in the AI product, but whatever you, that's what I love about the GDPR, the process perspective, because in the end, what product you are using within a specific process, and you had an idea why you decided to build this with a specific solution, right? And by looking at all that, it's what can help you to really realize, well, how can I affect not only the users of this application, but you need that holistic perspective. That's necessary. Now, the reality is that organizations, I mean, we need, and that coming back to what Catherine was commenting, we need some process. We need some risk management process, but that is eventually is a technical process and has to be adapted to your organization. And there's no questioning for me that we need that structure, that we need a way to learn how to identify risk, how to mitigate them, but that is not going to solve the problem of being able to see all the different risks that are there and harms.
Okay, yeah, perfect. I mean,
I would just like to add to that, because I find important to mention, from all what I hear today, I think I don't know which one of you mentioned about the rights of Europeans and the rights of migrants, and I think that from my perspective, a lot of we come into the complexities of the human society in itself. I mean, we cannot solve a problem of risk management just by having a technical process. That's out of question. I mean, risk management eventually cannot be a process that tells you who you want to protect and what you want to protect. And that is what is becoming one way or the other. But eventually it's a question also of attitude, of being able, how do we eventually, if the goal is to protect, to communicate that maybe that filter, that specific steps that need to happen in the proper way with dignity, respecting the dignity of everybody, because eventually that we need risk management, and we need to execute some of the process that happened that from other perspectives I've seen in a negative way.
And then we also see the rule of law connection of data protection, right? To have due processes, to have mitigating measures. But of course, there's also the issue with how we turn risk and against whom we turn risk, perhaps. And I wanted to get back to Irmak with, this is kind of unfair because it's your own question. Why do we use these technologies? Which is something that I always think about, because as a data protection lawyer, obviously you're always like, what's the purpose? Which is in itself already a critical question and gets you some flags sometimes. But I was just kind of wondering, what's your perspective then for the law enforcement sector? Is there a better way to use these technologies? Is there a better way of doing the enforcement, maybe without the technologies? What's your perspective on how could we get forward from where we are?
The first thing is like the terminology that are used for these technologies are evidence-based. And I'm like, what do you mean by evidence-based? Like, what is your evidence there? Is this data useful? Did it really help you figure out who really was supposed to recommit a crime and they really did? Like, what do we mean by that? It's like, first of all, questioning the terminology themselves. We should start there. And what you said, I really find important that at least these risk-regulated systems in themselves do not make reference to how to make it profitable, but make a reference to how to make it fundamental rights friendly. But when it comes to criminal law, we have to step further than being proportionate, because maybe if I can have my slides, I just want to refer to standardization in the risk management also. Can you forward one more? Or, okay, I have it, sorry.
I have no idea how this works.
Yes. So, I mean, the reasoning behind these technologies is, of course, not spending too much time and effort after the crime happens and protect the citizens beforehand. But looking at the scores, we see that if you take into account the data like the access to education, the family status, all this data, of course you have the underprivileged people receiving higher scores. Would it really fulfill the promise of objectivity? Would it really fulfill the promise of efficiency, which these technologies are used for at the first place? And of course, AI Act did a great thing by prohibiting certain red lines, but when it comes to high-risk related assessment technologies, which such categorization doesn't even exist in the US, but to give an example, the courts have diverging opinions. Some of them say, okay, it's high risk, but I'm going to use it because I have the evidence too. Why not use everything? Some courts say, hey, it causes us more time and effort to come through this already biased algorithms and try to detect where the bias is and whom it is affecting. Then we struggle to figure out what's happening with these technologies, and we had already many things to do. And why are we adding a second layer of this? How is it helpful to build suspicion? So in criminal law, the standard, there was a standard. The standard was reasonable suspicion, and if you're going to criminalize someone, it was like almost zero suspicion if it's feasible. And now we have these risk assessment technologies, which has nothing to do with suspicion standards, and we are trying to standardize them. And at least in Europe, as an example, this case I find really important is the German Constitutional Court. They said, okay, if no one is striking down these technologies, the courts will have to do it at some point if there are no foreseeable rules. Luckily, in Germany, there are some foreseeable rules. For example, for data mining, you cannot just go on internet, scrape everything for every kind of crime. It has to be for serious crimes, it has to be limited time, and there should be a supervision of the judges and so on. But for Palantir, suddenly law enforcement started to use Palantir, and then the court said, hey, all this data in Palantir, is it really relevant? Is it really proportionate? Then data protection regulations came into force with criminal law protections, and the result was good. But do we have to leave this to countries, really, that either they choose to regulate this or not, either they choose to strike down this or not, and suddenly all these judicial decisions are different from each other? So that's my question. Like, if you don't ask why are we using them, we cannot calculate their real efficiency promise, and also we have to deal with extra problems with bias and privacy. And sometimes even privacy regulations, data protection regulations wouldn't help us. Like in Alyosha's example, like let's say you are detecting ways that the migrants take. There is no personal data. We don't collect any personal data. So what's the point? Of course, there's a collective privacy concern there. And if you take all these technologies into criminal law, judging individual persons, we are like left with so many different paradigms. So my answer to that is it's very hard to standardize the use of these algorithms. And apart from the prohibited ones, unless the national domestic laws, there is right-based laws regulating them, there's going to be a chaos, is my answer.
Okay. Oh. Some more questions and some answers. Thanks for that. Of course, the German Constitutional Court is also known for saying you can't do this unless you have these requirements met.
Yeah.
And then, of course, they come again. So we'll see how that develops.
Yeah, of course. It's not the end of the
future.
story.
It's not, exactly. But then I wanted to come back to Alyosha and ask, because I know that EDRI doesn't just, I mean, obviously you do a very good job at pointing out things, but I know that you're also working productively with migrants and people who are affected by these rights violations. And I was wondering if maybe you can give us like a short overview or a glimpse into how it affects people on the ground, actually.
Yeah, thanks for the question. I believe that we are seeing, first of all, that now that the AI Act prohibitions have started to be applied, there's a huge gap when it comes to migration management, to borders, and so on, because many of them weren't part of the prohibition. So things like emotional recognition can still be used. So these prohibitions are not adopting there. And also in the high-risk systems that are in the AI Act, many of them, when they are used for migration or law enforcement, they don't have to fulfill transparency requirements, so we won't be able, as civil society, to scrutinize what's happening. So that's one part of the coin. We, as EDRI, will not be able to follow what's going on, so it's total opacity, and I really agree with Kate that this is code for deregulation. So the idea of putting systems that are used for migration purposes under zero scrutiny is just a way of, giving these private companies that are profiting from this way to test their technologies on migrants, to keep proliferating, and to do that without any oversight. So that's one part of the coin. And the other part is what are these effects that we are seeing on technology. It's partly also what was mentioned here, that in times of crisis, you hear easy solutions for complex problems. So we are facing that with techno-solutionist narratives nowadays. So they are talking about how you can solve all types of societal issues just by throwing technology at it, and one of them is migration. So there is this fake narrative in which data are neutral, and therefore if it's a machine that has learned how to take decisions, that takes the decision, it will be objective and it will be less biased than it, but all this takes as a first premise that data is neutral when it never is, as it was shown in the slides. And all this, the fact that this technology that you throw at these type of problems, what happens is that it oversees all the systemic inequalities that these populations are facing, and this is the main part that migrants are facing. So at the long-term harms that migrant populations are facing, such as racial profiling, the right to asylum being a right that they have and being upheld as what it is. They're facing digital exclusion, and they are facing mostly, and that's for me the most important one, they're facing lots of violations of their human dignity, because all these technologies are being tested on them as they are guinea pigs, and we know what happens at the beginning is tested without any oversight in borders, and then when it's deemed useful, it's put in the law that it can be used for law enforcement, and then the last step is it being used to control broadly everyone's society. So we are seeing that the effects of this techno-solutionist narrative on migrant population is the reinforcement of racialized surveillance, more and more racial profiling. Now it's not racist border guards that are being discriminating. Now it's machines who are doing exactly the same, but in a more efficient and fast way. So in a way, it is fulfilling the goals that they have to be more efficient, because it is automatizing discrimination and making it even harder. And yeah, it's all coming from the from the legacy of biometric control, because we don't have to forget that biometric data were taken as a way of controlling for the first time in colonies by the Great Britain. So it was a way of treating everyone who was living in the colonies as potential suspects. So they first started, for example, collecting fingerprints of all the population to do that. So we don't have to forget this is just enhancing these structural problems. And for me, the most relevant one is the invisibilization of all these harms. So we're talking about risks to us. We're talking about risks that some technologies can pose, to directly human rights, but we are in this way invisibilizing all the long-term structural harms that these populations are facing.
Perfect, thank you. Which is also a great lead over to what I wanted to ask Katie about now, which is what does it all lead to? Because we always had this rhetoric in the EU, of course, of like our values, our fundamental rights-based approaches. And then suddenly AI happens and we have this huge FOMO on the level of the Commission, which seems to kind of take over many of the approaches that we had, and that with flaws, obviously, but that in principle had like a different path or a different trajectory promised. So what do we do with this? Where do we go now? Because we hear digital sovereignty again over and over. What does that mean? And what would that mean for fundamental rights? Like how, do you know how we could do it differently? Because we obviously we don't want to have a Trump administration light kind of situation here, right? So what do you see in ways that we could, well, steer off that path?
Yeah. How do we fix the disaster? Big question. My background is law, so I tend to think of it from that framing, but I suspect many in the room have also a lot of additional insight to add here. I think, look, the EU has always asserted this fundamental rights value. I think we know that often that assertion is not, is not equally applied to everyone. Like I think, we've long, I'm thinking of that great article, the Brussels Affect, and I can't think of the authors off the top of my name, so to them I apologize, but that, there is the Brussels effect that has been trumpeted to the world. We protect fundamental rights. This is what we are to safeguard, but at the same time, we treat migrants on our doorstep very poorly. These rights that the EU often trumpets are not asserted to everyone. And yet, nevertheless, we know that the fundamental rights, insofar as they have legal form within the EU, have been therefore very useful. You know what I mean? I was talking about rhetoric, but within language or within law, form really matters. So if you have formal rights, you can use them, either to get redress, but also strategically in terms of raising awareness or bringing issues to greater public attention. And I think collective organizations and NGOs have been very effective in this. So I think that role has to continue. I think trying to coalition build and there are lots of us in the room who are worried about this. Lots of people across CPDP are worried about this and trying to find ways to work together to resist this push towards deregulation or towards the narrowing of who fundamental rights apply to, or certainly how those fundamental rights are implemented is going to be really important. And and thinking about authoritarianism and rule of law, I think, paying attention to the institutional balances within the EU is really important, that the Commission is grabbing a lot of land right now, and not necessarily always in compliance with, maybe what the CJU has said on comparable issues. So, to be, critical and ask the questions and not take for granted that what we're being told is or necessarily lines up with what's going to happen. Yeah, part of the story.
Perfect, thank you. Okay, I mean, I've had people talk to what I'm researching and taking notes, and it's been incredibly helpful for me, but maybe you also want to take the chance, because, and I already see some, the first one was here, then we have somebody in the line there. 3, 4, okay, yeah. And then maybe we just take 2 questions now, and then we'll take the other 2 questions, and then we'll see.
Yeah, thank you very much for this very clear panel also on the kind of trying the reductivist framing of risk. And I wanted to kind of piggyback on this because you made a lot of reference to risk management, but the way that I read at least the DSA, to me seems more like a risk governance framework and not necessarily a risk management framework. So I was wondering to what extent we can like strike this balance of like, for one, providing some solutions, right? Because like risks need to be to some extent operationalized, and then also like kind of acknowledging the uncertainty and to what extent this kind of space that the DSA arguably opens up is threatened by this very technical language in the AI Act as, this is kind of closing down the kind of discursive multi-stakeholder approach to risk based on this technical language.
Okay, perfect. And then we take the question from the Maciek in the blue shirt.
Hello, thank you. My name is Maciek, a PhD researcher at LSTS, and thank you for a very interesting panel. I'm very inspired. But I have actually very something that I see that we discuss a lot about how the notion of risk transform our law. But why we don't want to push back? Why we don't want to actually transform the concept of risk? For example, Niels van Dijk wrote a paper in 2015, Beyond the Risk, and he introduced the idea that, okay, maybe we should think about this process like this kind of upstream justification. So maybe we should think about fair trial protections, like right to be heard, or put other institutional elements, mechanisms that can actually allow the people that are affected by those risks contest those decisions, involve them in the process, like this is the call of public participation. This is one element, but more legal elements. And the question I have actually, I would like to direct is to Isabel. To what extent this kind of logic is visible in the work, in the process, in harmonized standards? Because as far as I understand, you work with harmonized standards. So to what extent this logic is visible in the process? And yeah, if whoever wants to think about it, feel free to reflect. Thank you.
Okay, perfect. Then maybe you can just see which ones you want to answer. I mean,
yeah, I can. Addressed. In fact, I thought I can almost answer both with one in one way, one clap, I would say. Let's see. Coming to your question about how to balance operational risk management with what we have been hearing today, right? That sometimes for me it's like we don't really have a solution. I mean, the truth is that we need internal controls. That you could call it like AI governance. When we are developing applications, we need to have some controls. We need to try to identify what can go wrong. We need to solve it technically. What you can solve socially, of course, but that thought has to be there. Now, one of the things that I find really important to say is that you don't, because like I mentioned before, you don't have a solution for everything. You don't have this lack of warranties. This thing of we are as people defining what is probable, what is the severity level that we think it's okay, yes or not. So one of the things that you do, and like coming to the standardization question too, is to implement what also has been mentioned here, the redress mechanism, is to involve stakeholders in the conversation. And in that way, well, getting the broader scope of that. I must say, and this is a personal opinion of me, from me, something, I mean, what we hear today, and again, I'm more in the technical aspect of risk management, it's not something we can solve because as society, we are a complex system. And the reality is that from my perspective, we can't keep debating about this, but what we really need is proper education on empathy. and how to understand what the others are feeling with my actions, with the things that I'm doing. And if I am not capable of seeing that, I mean, you cannot pretend that any technical team, and no matter how many stakeholders you have in the room, no matter if they are technical, if they are not technical, you need to have that capacity from the time when you are a child, and that brings me back to my story of children. It's not only telling them what can go wrong and how to protect yourself, it's understanding what is the effects of my actions, and how can I benefit society. So if we don't have as foundation as society those values, and I know it's very complex because, again, when we get with the geopolitical and the differences in cultures, and I know it's extremely complicated, but that already, as you can see, it tells you of the complexity of the problem. So if we cannot bring that empathy in the teams, we cannot really have 100% solutions, obviously not. And in that sense, redress mechanisms, a way, like you mentioned, that we are with empathy, with attitude, like I mentioned before, open to listen to, okay, I need to filter, I need to implement these mitigations, but I know people will be affected, and I need to listen to you. I want to solve it as soon as possible. And in that sense, sometimes laws are one of the main blocks to do that.
Okay, and then Alyosha and Irmak wanted to respond as well?
Yeah. I wanted to give an answer to your question on what can we do or how can we push back on that. So it's clear that the first thing we have to do is to ask ourselves, when we talk about risk, is it risk for whom? Risk of what, exactly? And who gets to define what that risk is, right? And when bringing it back to the field of migration, it's clear who is doing that. So now we are shifting our narrative around risk on the risk to our institutions or to our systems of power instead of risks for people. So we should stop in this case, and we as human rights organizations, that's what we actually do. We try to shift all this narrative, so from protecting institutions to protecting people. That's one part of the coin, and then the other one should be when it comes to legislation. For example, the AI Act has something that's a risk-based kind of framing, but we were at the beginning of the AI Act, we were pushing for it to be a human rights-based approach, because we think that whenever a legislation can have heavy or great impacts on human rights, that should be the center of the law. So not risks that when you frame something as a risk, as we said before, you're already assuming that that risk can be mitigated. Whereas if you do it the other way around, it's on the deployers or on the developers to make sure that they fulfill with human rights requirements that our law already has. So that would have been the best scenario, that we don't have a risk-based but a human rights-based legislation in this very particularly potentially threatening area. But now that we have this already, we will for sure push for it to first of all be applied. Now we are in phase of the start of application of the AI Act prohibitions, and we're already seeing some countries like Hungary trying to overrule that and use RBI on demonstrations on the Pride. Now that's a hot topic currently. So now we have to push for the yeah, thank you, for the Commission to apply the AI Act strictly, and then we can move forward.
Okay, then maybe Irmak.
Very short
go ahead,
comment,
yeah.
because I like the question between the differentiation between risk analysis and risk management. I think all of these tools, AI Act, DSA, is doing something nice, not assuming that the state can also get the knowledge of everything and letting other actors into the game, let's say. But, and also according to their power, it categorizes them and it tells them what their responsibilities should be. But the only thing missing, to my point, is risk management depends on the information and the full information. And now the information is shaped by the actors, and we have like a distilled information reaching to the authorities. And in that sense, what we are missing is missed opportunities like regulating whistleblowing better, like regulating all this. Like, we shouldn't expect everything from one regulation, but at the same time, unless we have these counterbalances, this information is not going to be enough to neither manage the risk or to make it human rights friendly.
Okay. Katie, did you want to?
No.
Okay. Then we do one last question from, there was somebody in the back. Yeah. And then we'll do one final round. And then, sorry, maybe you can ask your question to the panelists later. Yeah, they're in the back.
Thank you. I'm Rodrigo Glasmayer with Leiden University, and I would like to bring the discussion to the necessity of transparency in the definition of the risk appetite of the regulator, the Commission in the case of the AI Act. And if you see that this technical framing of the risk categorization takes the political discussions out of the public eye.
Okay. Anybody?
If the risk categorization makes the public discussion out of the eye.
Yeah, I mean, I think the extent to which the Commission is taking on these kind of delegated legislative powers and, you know, the flexibility that's being put into lots of legislation is within the hands of Commission is increasingly challenged given the kind of geopoliticization of tech enforcement at the moment. Like we've seen some of this in the DSA, that there's worries about the extent to which the Commission's other roles, you know, the Commission's role in terms of trade policy or external policy is impacting these other aspects. I think that's a concern, yes, and I think ensuring that other institutions and other stakeholders and actors have a say in this stuff is really important. That, yeah, there's another risk. Here we go. The risk that the Commission is cementing a type of executive decisional power over a lot of these aspects. That, yeah, I certainly have some concerns about.
Mm-hmm. Okay, I think then we'll just wrap it up at this so that everybody has a chance to get their lunch. Thanks again to all the speakers, and thank you for coming. And
Thank you.